The Supreme Court has strengthened protections for religious accommodations in the workplace with its recent ruling. On June 29th, the Supreme Court issued a decision in Groff versus Dejoy, Postmaster General, which strengthens protections for religious accommodations in the workplace. At issue in Groff's case is Title VII of the Civil Rights Act, which prohibits religious discrimination in the workplace and requires employers to reasonably accommodate an employee's religious observance unless that accommodation imposes an undue hardship on the business. In 1977, the court defined such a hardship as an accommodation that would place more than a minimal burden or de minimis cost on the company's operation. Instead, with this recent ruling, the court ruled that an undue hardship is shown when a burden is substantial in the overall context of an employer's business, and the test must be applied in a manner that takes into account all relevant factors, including the particular accommodations at issue and their practical impact in light of the nature, size, and operating cost of an employer. The court said that the ruling should result in few, if any, changes to the EEOC's guidance explaining why no undue hardship for religious accommodations is imposed by temporary cost, voluntary shift swapping, occasional shift swapping, or administrative costs. However, due to these potentially increased obligations to meet an undue hardship threshold, it is recommended that employers train managers and supervisors on handling religious accommodations requests and the interactive process, and that you review and update your policies as needed. In some cases, it may become imperative to seek the guidance of an employment and labor attorney to determine if an undue hardship exists. Notably, the court's opinion did not address whether the Postal Service should have accommodated Groff's request not to work on Sundays, and the ruling sent that back to the lower court to apply the new undue hardship standard.